Hi, good afternoon if you're on the East Coast, good morning if you're on the West Coast. This is Aaron Lacey. You're listening to Decoding the Final Borrower Defense Rule webinar series. This is the second in our series of 4 webinars on this topic. I am a partner here at Thompson Coburn. It is a law firm. We have about 400 attorneys, and I'm physically sitting in St. Louis, so I can see the St. Louis Arch today from through my window. I'm in our higher education practice, and we do a lot of different things. The folks like me who practice sort of in the regulatory space divide what we do up into 3 buckets. Usually, one is providing guidance on regulatory matters like the bar defense rules or gainful employment or all the wonderful rules and regulations that accompany the federal financial aid programs. We also assist schools with all kinds of transactional contract work, drafting, negotiating, and creating policies, those kinds of things. And then finally, we will represent schools in administrative proceedings. So that could be a program review or an IG investigation or anything along those lines, an accreditation action. Before I was at Thompson Coburn, I spent about 4 years in-house with an institution of higher education. So I have been on the other side of the line. And deeply appreciate that when the webinar ends, you all have to take all of this and all of the other things you deal with every day and figure out how to implement that and work through it in real life. And prior to that, I spent about 8 years with a law firm in Washington, D.C., there again practicing higher education law. Here's the outline. I'm going to touch on politics and prognostications. If you listened in on Tuesday of this week, you've heard some of this, so I'll move through it briskly, but these are important topics. Then we're going to talk about the new rule from 40,000 feet, and then we're going to dive into today's topic, which really is the new financial responsibility aspects of the rule. We'll talk about the framework, and I should say, and this is a situation where the final rule in some very significant ways changed from what was proposed back in June. So we'll talk about how those changes look and how they function. It's interesting and in some respects very complicated stuff. So good to get through and to try to wrap your brain around. So let's talk with, start first with politics and prognostications. You know, the salient question I think you have to ask if you're listening to this webinar or if you are operating in any regulated industry these days is what's happening next now that we've had this sort of significant election and all of these changes? Will this rule ever go into effect? Hard to say. I think there is absolutely a possibility it could be killed. There's no doubt about that. Congress has at its disposal something called the Congressional Review Act, which was a piece of legislation that came into existence back in 1996, and it permits them to enact a, quote, resolution of disapproval, which essentially means they can kill a rule provided that both houses of Congress and then the President agree to do so. Congress also has to do this within 60 legislative days of the rule's introduction. But remember, legislative days are different than calendar days, right? So you only get so many legislative days each month. The salient point here is the borrower defense rule would certainly be covered. So Congress would have plenty of time if they wanted to go the route of a Congressional Review Act type piece of legislation to include this and to kill this regulation as part of it. Couple of important points. One is a CRA Act or a piece of legislation pushed through under the CRA is filibuster proof, which makes a big difference here, right? So you don't have to get 60 votes or more to get it through. The other really important point is under the CRA, if Congress in fact kills a rule, then the agency is prohibited from introducing a substantially similar rule in the future, which is really significant because there are a lot of points that are touched upon in this rule package, and in theory the department would not be able, if Congress did in fact move to kill this, they wouldn't be able in the future to bring any of these ideas up or some of these similar ideas up, or they would have to work around that prohibition if they did so. Couple other ways that this rule could be impacted, even if Congress didn't take action, certainly the administration could act to remove it through rulemaking. Now that would require, you know, initiating a new rulemaking process, which would take many months, and they could strip out all of the rule or parts of the rule or change it. They could also say, well, we're just going to suspend enforcement of the rule for the time being. And that is very helpful in most respects. There are a couple of aspects of this rulemaking where the department saying we're not going to enforce the rule still might not provide the solution that one would hope for, and we'll talk about that in our last session. Particularly, I'm referring to the arbitration provisions. So now the question is, well, Aaron, if you think this rule is likely going to get killed, why should I sit through 6 hours of content on the rule? Well, there's several reasons. One is, apart from just being a policy wonk and being terribly interested, first of all, Congress may not act, right? Keep in mind, though this piece of legislation, the Review Act concept has been around since 1996, it's only been used once, right, successfully, so it's not something that's pulled out on a regular basis. And there's a lot on the plate of Congress right now. It's interesting, the Congressional Review Service, I mentioned on Tuesday, has done a couple of papers very recently on the Congressional Review Act and some of the other options that the next administration will have with regard to how they might want to repeal or otherwise treat rules that were passed by the prior administration. But they did a whole piece on the Congressional Review Act, and they cited in this paper all of the different rules that might be covered, and bar defense didn't even make the list. And the only reason I point that out is to highlight that there are lots of things that different agencies, lots of rule packages that have been put through by lots of different elements of the government in the last few months. So the only way that this gets captured, even if there is a CRA, is if it's on people's radar. You know, I think Lamar Alexander, the chair of the Help Committee, and Virginia Fox, who's probably going to be leading over the Education Committee in the House, I mean, they are aware of it. I think it is on their radar, but still, a lot of competing concerns. The other thing is, even if this specific rule were to go away, remember there is a bar defense statute and some regulation that already exists, and more to the point, there are literally thousands of claims that have been filed with the department. So there is going to be a process pursuant to which to deal with bar defense claims. And one of the things that this rule can tell you is how the folks at the department are thinking about the way those should be managed, even if this rule doesn't specifically pass, because there will be folks at the department, even under the new administration, who were part of the prior rulemaking or who may have some understanding or feelings regarding how all this should be managed. So there are a lot of reasons to keep it in mind. So let's talk about the new rule from 40,000 feet. I've mentioned before, you guys have seen this slide if you've listened in on some of my presentations, that there's a lot that goes into this rulemaking. It's not just bar defense, even though that's the headlining concept. Today we're going to be talking about the financial responsibility triggers and that component, which is significant, almost in my mind, if not as significant, maybe even more significant than the bar defense element. And then you've got all these other aspects as well, arbitration, revisions to closed school and false certification, discharge, et cetera, and we'll be talking about those next week. Here's the implementation timeline. Again, assuming this rule did stick around, so you know it went through negotiated rulemaking earlier this year, proposed rules came out in June, comment period closed in August. The final rule was published November 1st, and it will become effective on July 1 of next year if nothing happens, if it's not removed by Congress or the next administration doesn't attempt to do something with it. Let's talk about financial responsibility fundamentals. You need to have a good understanding of what it's about now to understand and appreciate the changes. I was going to say the proposed changes, but these are actually in the rule. So to begin and continue to participate in the federal financial aid programs, particularly those of you who are in FA, you are aware that an institution has to demonstrate a couple of things. One is that it's administratively capable, and the other sort of big categorical thing that you have to demonstrate is that you are, quote, financially responsible. The Higher Education Act generally authorizes the department to establish reasonable standards of financial responsibility. And with a little more specificity at another part of the Act, the HEA provides that these standards have to assess whether an institution provides the services described in its publications and statements, provides the administrative resources necessary to comply with HEA requirements. So that's sort of interesting that this administrative concept is actually captured under the financial responsibility umbrella and meets all its financial obligations, including but not limited to refunds and repayments owed to the department. So pursuant to this authority, the Department of Education, because remember, that's the statute, so Congress put that stuff in the Higher Education Act. Pursuant to that authority, then, the Department of Education has come along and crafted standards of financial responsibility. The general standards of financial responsibility are found in 668-171, and I've put here for private, nonprofit, and proprietary institutions. There are also standards, or there is a standard for public institutions, but it's different, right, because they are considered to be backed by the state. So the way that the department determines whether a public institution is financially responsible is a little bit different. There are some additional financial responsibility factors at 668.15, which is a different section of the regulations. That is an older part of the law. It is still good law in the sense that it has not been removed from the books, and I have seen the department periodically refer to it. But even in the preamble accompanying these final regulations, the department sort of acknowledged that the controlling standards of financial responsibility these days are the ones found at 668-171. At least the primary framework that they operate pursuant to, it's at 171. And the other thing that's worth noting is all of the changes that were made with this final rule were made to 668-171, so without even reference to the additional factors at 668.15. So this is the current framework. Remember, the new rule doesn't go into effect until July 1, 2017. So this is what the current framework looks like. Historically, and you all, again, if you're involved in the finances of an institution, the financial aid office, you're probably going to be familiar with some of these. So to be financially responsible, the department, it's going to look at your composite score, right, which is this series of, it's a single score that's based on sort of 3 subcomponents or ratios. You have to have sufficient cash reserves. You have to be current in your debt payments, right? You have to be meeting financial obligations. You have to have a clean audit. So if you have everyone, even if you're a nonprofit, everyone has an annual audit. They're a little different. The nonprofits have an A133, but you all have one. And if you have a qualified opinion, that can implicate whether or not you're financially responsible. And then there's also this past performance concept. You can't be violating the past performance provisions. And what that says is there are certain people at your institution who can't have been associated previously with an institution that closed owing a liability to the department or certain other things along those lines. So if the department determines that an institution does not satisfy these standards that are at 668-171, and those are the ones I had on the prior slide, the department can permit an institution to participate, continue to participate under an alternative standard, and those alternative standards are set out at 668-175, and there are sort of 3, if you want to imagine them, again, big picture. One is you can post a letter of credit, and if you just go with the straight letter of credit option, that means you have to post a letter of credit in the amount of 50% of your institution's prior year Title IV receipts. For most folks, this isn't an option because that's going to be a giant number. The second is called the zone alternative. It's only available to schools in certain circumstances, and it doesn't include a letter of credit component, but it does require that you comply with a host of other cash management and reporting limitations. And then finally, you can continue to participate potentially under provisional certification, which is sort of a combination of the 2. You're provisionally certified, you have to post a smaller letter of credit, and you still have to comply with the zone alternative. So the point is, though, that you are able, even if you're not financially responsible, there are ways that an institution can continue to participate in the federal financial aid programs. And in fact, many, many institutions do. If you look, every year the department now is starting to publicize and make available on its website, or if you don't know, I'm letting you know, information regarding all the institutions' composite scores, and also information now regarding who's on HCM1 and who's on HCM2, et cetera. So it's pretty easy to get a sense as to how many institutions are participating under some sort of option because they've failed financial responsibility, and it's in the hundreds. Last time I checked, I think it was 400 or 500, something in that range. Also, you should note, the department, if you fail financial responsibility, does have the opportunity to initiate a fine, limitation, suspension, or termination proceeding. And for an institution that's provisionally certified, if you continue to fail, they have an option to initiate what the department calls sort of a show cause proceeding. It's different from what your creditor would call a show cause, but it's conceptually the same in the sense that you're sort of getting one last chance to demonstrate why you shouldn't be bumped out of the programs. So what's new under the new rule? The new framework has some elements that are the same, right? And that's the color coding here. The blue is the same, and the orange is new. So they're still doing a composite score calculation for you, and you're still going to have to pass that. You still have to have the sufficient cash reserves, and then skipping down, past performance is still in place, and you still have to have a clean audit. But the big new concept here is there is a new standard of financial responsibility that requires that institutions meet their financial obligations and provide the administrative resources necessary to comply with financial aid requirements. Now, here's what's interesting. This language that is new to the regulation actually more closely mirrors the language in the HEA. So Congress, when it initially created, it said, this is the purpose of the financial responsibility standards, department, go forth and, create some regulations. They actually said one of the things that the financial responsibility should do is ensure that institutions, again, meet their financial obligations and provide the administrative resources necessary to comply with financial aid requirements. And what's interesting is the department, once upon a time, didn't have a regulation that sort of mirrored that language. Well, now they do, and that's part of what has been introduced here. But then what they've done is they've said, okay, so we've got this new standard that you have to satisfy, the one regarding financial obligations and administrative resources. So what we've done is we've articulated a whole bunch of these actions and events that if one of these occurs, we will not consider you to be satisfying this standard, right? So they included a new sort of umbrella standard, and then they've added this laundry list of actions and events or triggering events that would potentially indicate that a school is not satisfying this standard. So that's how this is all sort of structured. The final rule creates 3 classes of triggering events, and this is totally different from the proposed rule, right? So if you sat in on our webinar series on the proposed rule, this will be new. There are 3 classes of triggering events now, right? The first class is what I'll call the automatic triggering events, okay? And so for any event in this class, the department would project a new composite score, right, use that new projected composite score as the basis for financial responsibility determination. So again, if one of these events occurs, what the department's going to try to do, it's going to take your most recent composite score and it's going to say, we're going to make some assumptions about the financial impact that this event is likely to have on your institution, and we're going to recalculate and project a new composite score for you. Right? And then it's going to be that new composite score that will determine whether or to what extent we deem you not to be financially responsible. So you've got a set of events that fall into this first category. The second class is automatic triggering events, which upon their occurrence would automatically result in a finding of failed financial responsibility. So there's no recalculation of the composite score, right? If one of these occurs, upon its occurrence, you automatically would be deemed to have failed financial responsibility. And in the proposed rules, sort of everything was falling into this middle category, right? So this first category with the idea of recalculating the composite score, that's brand new, right? And then in the third category now, we've got what the department is calling discretionary triggering events. And these are events that the department could elect to take into consideration and try to demonstrate that they're going to have a material adverse effect, that's an MAE, on your financial responsibility. So if one of these events occurs, it's not automatic, but the department may look at that event. You have to still report it, and they may say, we believe that this is going to have an MAE or constitutes an MAE, and we're going to demonstrate that, right? And that would be the threshold for ultimately determining that you lacked financial responsibility. So I mentioned in the outset, the new framework's more complicated, and it really is, right? Now you've got these 3 different classes of triggering events, and whether and to what extent you are deemed no longer financially responsible is going to start at the outset, depends on which one of these buckets you fall into. So why, by the way, did the department do this? I mean, why would they come up with this much more complex scheme? If you listened into our prior webinar series on the proposed rules, one of the things we talked about that we thought was a real issue, and a lot of people thought was an issue, and they commented on it when they submitted their comments, was that the department was trying to come up with all these materiality standards. So, you know, you had these different kinds of triggers, right? And the department was saying, okay, if you've got litigation, right, then we're going to consider it material litigation if the claims involved in the litigation exceed 10% of your institution's net worth, et cetera, those kinds of tests. So the problem was the department was trying to come up with sort of a one-size-fits-all materiality standard and to apply that to all different kinds of institutions. And a lot of people came back and said, well, this doesn't make sense, right? I mean, what is material for one type of school based on its size or its structure, et cetera, might not be material for another. And so the department said, okay, we understand that coming up with the one-size-fits-all materiality standard is problematic. So what we're going to do is, instead, we're just going to take into account the event, and then we're going to recalculate the composite score, right? Because that will be, that recalculation, though it is still a projection and no doubt will be subject to criticism, it nonetheless is a calculation that is specific to your institution. Right? So if we evaluate whatever we think the event is and we do this projected composite score for you, and indeed it is not material, then it should not impact your composite score and you will not be deemed to lack financial responsibility, right? So that's the idea by creating this whole first category where you project and recalculate the composite score. That's essentially the department's alternative that they've come up with in the final rule to calculating materiality, right, and figuring out how meaningful is this event to the institution's bottom line. But again, you still got some events which would be automatic and for which there is no recalculation of the composite score. In other words, if one of these things happens, the department basically says, we think it's material, and so you lack financial responsibility. And you've also got this other discretionary category where the department is sort of putting on itself the burden of demonstrating materiality, but gives itself flexibility to do that. So what are the actions and triggering events, categorically speaking? So you still got debts and borrower defense-related lawsuits. That's a category. Other litigation, so that's litigation claims, things that don't involve borrower defense type issues. Accrediting agency actions, gainful employment, and that's referring to the debt-to-earnings ratios for your programs. A withdrawal of owner's equity, failure of the 90-10 rule, so that would only apply to for-profits, as would withdrawal of owner's equity. Publicly traded institutions, certain triggering events, again, that would be only applicable to for-profits, cohort default rates, and discretionary factor or events. So I think I've named them, but just to be clear, the three here that would only apply to for-profit institutions are withdrawal of owner's equity, 90-10, and publicly traded institutions. All the others could apply to any type of institution, even gainful employment, right? Because you all know if you're at public or nonprofit institutions that offer non-degree programs, that those are also deemed gainful employment programs. So what's the color coding? Well, let's just go back. So look, see, I've got category 1 is green, category 2 is dark blue, and category 3 is orange. So the color coding is consistent here. So the green items on this slide are the items for which you would have a recalculated composite score. The dark blue are the ones that would be automatic. There would be no composite score recalculation. And the orange at the bottom, that's the discretionary factors or events. Let's talk about materiality for a second, because it's a really important concept. In all cases, and this is also new, and this was a major point of contention in the proposed rule because this this concept wasn't there. In all cases, in the final rule, institutions will have an opportunity to demonstrate that a triggering event no longer exists, has been resolved, or that the institution has insurance that will cover part or all of the debts and liabilities that arise at any time from the event. So now we don't know to what extent, you know, this has what it would take for you to prove that these things are or are not true, and to, you know, what extent or at what point the department would say, okay, we are satisfied that you are no longer financially lack financial responsibility. So using a concrete example, you know, let's say that you show that some event occurs, you report the event, but then you also demonstrate that you have insurance that covers part of the debts and liabilities. Okay, well, how much has to be covered for the department to say, okay, the risk is negated and we consider you to continue to be financially responsible? So, you know, that's going to be something that's going to be part of the conversation with the department when one of these occurs. For triggering events requiring a projected composite score recalculation, so that's that first category, right? Institutions also may attempt to demonstrate that the event has had or will have no effect on the assets and liabilities of the institution when the composite score is recalculated. So in some ways, this is a similar concept, right, to the first category, but it's getting very specific to the idea of how your assets and liabilities stack up in the context of the composite score recalculation. Processes and consequences, and we'll talk about all this in a little more detail towards the end of the presentation, but I thought it fit to sort of hit on it now. So this is the way, procedurally, this would all work. You would have a triggering event that would occur, and then the institution would be required to report that event to the department. Typically, it's within 10 days, but the department has included in the final rule a very complex scheme, and exactly when you're required to report, how long you have, it really is specific to the individual underlying triggering event. So there's a whole schedule. And one point I'm going to make here that is important to note is your financial aid office is not going to be aware of all these events when they occur, right? I mean, some of them are litigation or investigations, things that your financial aid office may not even know about, right? So it's going to be really important if this rule sticks around that the general counsels and the compliance folks and people in HR, you know, somewhere you need to have a schedule of these triggering events and the timetables for reporting. It used to be that there were a pretty limited number of things that you were under the law required to report to the department. You know, I mean, you had certain changes to your e-car you had to report, of course, and then if you had someone who committed financial aid fraud or whatever, you have these obligations to report to the IG. But this is layering in a whole new series of reporting obligations to the department, right? And you're going to have to coordinate with all aspects of your institution. I mean, my experience in chatting with people over the last 6 to 12 months has been that not a lot of general counsels are paying attention to this rule, particularly at traditional institutions. And that's understandable. I mean, if you're the general counsel at a large private nonprofit, financial aid, rightly or wrongly, isn't typically something they spend a lot of time on. This is going to be one where your financial aid folks need to write this stuff down and go talk to the GC and say, look, I mean, if we have some sort of litigation that occurs, I'm not going to know, but we have a reporting obligation, so you have to have this on your radar, right? Somebody's got to be paying attention so we can coordinate and make sure we're reporting whatever we need to report, okay? So triggering event occurs. You have to report the event within the prescribed number of days. The institution may provide evidence that the event is non-material, right? So that's a new concept in the final rule, which is important. As applicable, the department projects the composite score impact of the reported event, right? So in some cases, they're going to do that. In some cases, they wouldn't. Depends on the event. If it's one of those events where they're recalculating and projecting a new composite score, if that projected composite score is less than 1, or the triggering event is one of the automatic events for which a composite score isn't required, then the institution is no longer deemed financially responsible. I believe the less than 1.0 here threshold, I think this is the only slide in the whole presentation where I make that point. So let me just reiterate it. In cases where they are recalculating and projecting a composite score, the threshold for whether or not under the projected composite score you are now deemed to lack financial responsibility is 1.0, right? So you got to be 1.0 or better. If it's less than 1.0, you lack financial responsibility under the new rule. The institution may participate under provisional certification, as I mentioned before, or potentially one of the other alternatives. And then the institution must provide financial protection to the department in the amount that is agreed upon and potentially comply with the zone alternative requirements. Just wanted to talk a minute then about recalculating the composite score. So this gets really in the weeds. Some of you actually do this, some of you will not, and you know, I didn't want to get too far afield here and trying to get into the details of how you calculate a composite score. But it is a general matter. What I wanted to point out was you're going to start with the institution's most recent financial statements, and then the department is essentially going to, and this is how they describe it in the rule, account for the actual or potential losses associated with the actions or events, and based on that accounting, recalculate the most recent composite score, right? So one of the million-dollar questions is, in the case of each of these different types of events, how does the department determine your exposure? And there is some discussion of that and some detailed discussion of that in the new rule, and that is detailed in Appendix C to Subpart L, right? So you may recall, if you ever mess around with the regs, Appendix A and B to Subpart L describe the composite score calculation for for-profit and nonprofit institutions, respectively, right? So a new Appendix C has been added And it essentially details how, in the case of a recalculated composite score, certain types of exposure would be determined and factored into the projected recalculated composite score. I'm not going to go through this in detail, but this is what Appendix C looks like. And so what you can see is, I know this is super tiny, but the first row, these are the different events. By the way, this is for proprietary institutions. So you've got the type of event in the first row, and then the second row tells you how the department is going to determine that loss, right? And then the next two rows show you how literally that loss is then factored into the different components of the composite score. And if you look, there's a very similar chart for nonprofit institutions. And both of those are in Appendix C. So if you want to really try to get into the weeds on how different events that might occur would impact your recalculated composite score, you can do it right here. Discussion of select automatic triggering events. So I wanted to just take a few hypothetical situations and try to get into a little more detail so you could see what the department is thinking. We're not going to go through every one of them, but we're going to hit several. All right, debts and BD-related lawsuits. So remember, there are a couple of categories involving litigation. The first one is debts and BD-related lawsuits. The second one is just, quote, other litigation, so any type of litigation that isn't covered by this. Now, I'm about to throw a lot of information at you. And that's not so you can try to memorize it all or absorb it all and process it. It's really just to give you a sense of how complicated understanding the impact of some of these events can be. And also, again, to emphasize the extent to which, if this rule sticks, you're going to have to get your general counsel or legal counsel or those folks involved, because there is no way that someone in financial aid or even a CFO or anyone who's not involved in these matters is going to know when some of these events occur, right? So what is the triggering event when you're talking about debts and BD-related lawsuits? If the institution is required to pay any debt or incurs any liability arising from a final judgment in a judicial proceeding or from an administrative proceeding or determination or from a settlement. So that's the debt piece. Or the institution is being sued in an action brought on or after July 1st, 2017 by a federal or state authority for financial relief on claims related to the making of a direct loan for enrollment at the school or the provision of educational services, and the suit has been pending for 120 days, right? So you're going to need to know what kind of litigation is out there, how long it's been around, what's the basis of the claims in the litigation, who's bringing the action, right? You're going to need to know and be sort of tracking these debts and judgments and when they occur, because these are triggering events. So if one of these things happens, you now have an obligation, and also it could impact your financial responsibility ultimately, right? So you can see these are complicated concepts. What is the reporting time frame? So for debts arising from lawsuits and for other actions or events, it's 10 days after a payment was required or a liability was incurred. And sometimes, you know, it can be hard to figure out exactly when that is, right? Because you may have a lawsuit that's been ongoing, or you may have some sort of settlement or something, and when that liability actually first accrues and is owed, you know, that can be a very specific date, but it may not be readily available to everyone, right? It's only going to be the folks who are really involved in this. Even if you may know that there's some judgment out there, you're going to need to be in communication with the folks who are really managing this. For BD-related lawsuits, it's 10 days after the institution is served with the complaint and 10 days after the suit has been pending for 120 days. So either one of those, right, would be triggers. And again, that means you're going to have to be in touch with people and make those people who manage these types of things aware of these reporting obligations. How is loss determined for BD-related lawsuits, right? Because if it's, incidentally, if it's debt, I mean, that's the amount of the loss, right? It's the debt. But in the case of a BD-related lawsuit that's been filed or is pending, right, where there's not yet been a judgment, I mean, how do you determine the exposure? Because remember, I want to make this clear, you're obligated to report as soon as you're served. So you could still be months or years out from the litigation concluding and determining whether or not you have any actual liability. That's not the point here. To be very clear, you know, you have an obligation to notify the department, and there is the potential for a suit to impact your financial responsibility just on the basis that it's been served, right? Not on the basis that there's actually been some sort of judgment. That's a really important concept to understand here. So let's say you've got a BD-related lawsuit, and just to give you a hypothetical, you got a student or a group of students who say you committed some sort of substantial misrepresentation, or there's a breach of contract, et cetera. But it's one of those that we talked about on Tuesday would be a basis for a BD claim, and they're going to also sue you, right, in state court or federal court, and you've been served. So now you've been this obligation has been triggered, and you have to report it to the department. How's the department going to determine the loss for purposes of recalculating your composite score? So it's the amount set by a court ruling, if there's been one, or in the absence of a court ruling, the amount of relief claimed in the complaint. If the complaint demands no specific amount of relief, the amount stated in any final written demand issued by the agency to the institution prior to the suit, or a lesser amount that the agency offers to accept in settlement of any financial demand in the suit, or if the agency stated no specific demand in the complaint in a pre-filing demand or in a written offer of settlement, the amount of tuition and fees received by the institution during the period and for the program or location described in the allegations in the complaint. Right, so that's a lot to take in. And you can see the exposure potentially of the loss that the department would use in recalculating your composite score can be tied potentially just to the relief claimed. Right, so again, it doesn't mean that there's actually been any type of judgment or decision on, or you will ultimately have to owe anything. It could be that you're victorious, right? What can an institution do to mitigate penalty in this case? And I don't mean sort of taking a big step back, what kind of policies, procedures, things you could do to keep things from happening in the first. I mean, if you're actually in this situation. So what the department will offer you is the opportunity to demonstrate that the claimed amount exceeds the potential recovery because the allegations in the complaint, if accepted as true, and the claims asserted, if fully successful even, could not produce relief equal to the amount claimed or the calculated exposure, because the allegations pertain to a period, program, or location for which the full recovery possible is a lesser amount. Again, I'm not, I don't want to get too into the weeds on this, and my point isn't, don't try to absorb all this necessarily. Just understand that when you're talking about, one of these scenarios with litigation, this is complicated. Knowing when you have to report is complicated and is going to require the involvement of someone who's paying attention to, when you get served with litigation or how long it's been pending. Trying to understand the potential exposure is going to involve this type of calculation, trying to discern what you think the maximum actual recovery is versus the claimed amount, et cetera. So so take a deep breath, we'll move on to the next one. Accrediting agency action. So what's the triggering event? If the institution was required by its accrediting agency to submit a teach-out plan for a reason described in this regulation, 602.24C1, that already exists, that covers the closing of the institution or any of its branches or additional location, right? So there's already this reg that basically says, if you have a closing of an institution or one of its branches or additional locations in certain circumstances, a teach-out plan has to be provided. And what the department is saying is, okay, so if under this reg an event occurs that requires a teach-out plan, that's the triggering event. If your accrediting agency is requiring you to submit a teach-out plan for one of these reasons, then you have to report that to the department. So what are the four things? Teach-out plans are required under the law if the department initiates an emergency action or FLST proceeding. That seems pretty reasonable, right? The accreditor acts to withdraw, terminate, or suspend accreditation. Also, that's a big-time event. So it's very easy to see how either of one or two would implicate the financial stability of most institutions. 3, the institution notifies the accreditor that it intends to cease operations entirely or close a location that provides 100% of at least one program. A state licensing or authorizing agency notifies the accreditor that an institution's license or legal authorization to provide an educational program has been or will be revoked. So the one I'm sort of focused on, I guess the last one, I had an initial concern, and I talked about this in the series we did on the proposed rule, that you could, under friendly circumstances, voluntarily choose to discontinue a program or even a location, educating a location. As a consequence, a state agency might notify your creditor or put out some sort of letter that your license or legal authorization is being revoked. That's not because you've done something wrong, but just because you've essentially said we're teaching this thing out or we're closing down or we're not offering the program, and just as a mechanical matter, so the agency revokes or removes that approval and notifies the creditor. And my concern was, well, that's going to trigger this requirement, and that's a problem. The department actually responded to that comment in the preamble to the final rule and essentially said, look, you know, if that happens, that wouldn't be a triggering event. I don't know. I'm always a little concerned about, you know, when the department's response to something is just trust us. But it does seem like the framework has shifted enough here, and there are enough opportunities, as I talked about earlier, for an institution to demonstrate that something's not material or isn't going to have an impact, that if you had something like that where you had voluntarily discontinued a program, that it wouldn't be an issue. I'm more concerned with number 3, right? The institution notifies the accreditor that it intends to cease operations entirely or close a location that provides 100% of at least one program. My concern is that institutions routinely do this. Large, healthy, financially stable institutions, and many of you may be on the, you know, you're on the phone right now, or you know schools that fit this category where they have lots and lots of extension sites or additional locations. You know, I know there are some nonprofits that may have 40 or 50 additional locations on their e-card because they are at military bases, they are on places around the world, and these are essentially satellite or additional locations where they're offering education to a smaller population, right? If you decide to close one of those locations responsibly, the market has changed, you don't like being there anymore, you don't have enough in the way of enrollments, et cetera, and you make a determination to just close that location responsibly, it would still trigger this requirement, right? Because under federal law, you are required to provide a teach-out plan to your creditor if you determine to cease operations entirely or close a location. And what that means is, it would trigger this financial responsibility standard and require the recalculation of your composite score. Now, presumably, you would be able to demonstrate to the department, and when they recalculated your composite score, it would show that this was not a material event. In fact, you know, if you, and this is one of the comments we made to the proposed rules, we said, well, you might have an institution where it is financially responsible for them to close a location. And so, again, the department responded to this comment in the preamble, and what they said was, well, if it's a financially responsible decision for an institution to close a location, it will still trigger this requirement, but when we recalculate the composite score, it should potentially show even an improvement, right? Hopefully that is the case, but it still troubles me that they have created a mechanism that would require institutions to go through this process and the recalculation of a composite score, even if someone is responsibly closing an additional location. And again, I would point out that this is going to apply even if you are a nonprofit or a public institution. Remember, I mentioned earlier, there's a different standard for ultimately determining whether or not a public institution is financially responsible, but it is unclear to me whether if one of these events occurs, a public institution would still have to at least report it to the department, right? And again, you know, my read on the structure of the law is that it's possible that they would. So even if you're a public entity, you would at least have to report the information. So what's the reporting time frame? 10 days after the institution is notified by its accreditor that it must submit a teach-out plan. How is loss determined for accrediting agency actions, right? So for a closed location or institution, the department has indicated that it's the amount of loss is the amount of Title IV HEA program funds the institution received in its most recently completed fiscal year for that location or institution, right? But we get even more specific, and this is, you can tell this from that Appendix C chart. The department will recalculate the composite score based on that loss of Title IV funds, right, from the prior year, and, importantly, by reducing the expenses associated with providing programs to those students. So this is where the department is trying to say, okay, look, if you're responsibly closing the location, what we're going to do is when we recalculate the composite score, we're actually going to reduce the expenses when we project that would have been associated with trying to provide programs to those students. So if you're saving, right, money by closing the location, and you're no longer subject to the expenses that are required to run that location, then that's going to be factored into the composite score. So again, it seems to me like the department has created an acceptable mechanism potentially for ensuring that institutions that are making responsible decisions aren't penalized. But, you know, I'm one of those folks. It's still irritating to me that you're forcing an institution to report and go through all these hoops and calculating a composite score. It seems like it would have been very easy to somehow tweak the rule so that if an institution was responsibly closing an additional location, it wouldn't even flow into this process in the first place. Different point of view, I'm sure. All right, gainful employment programs. So this is one just that will primarily affect for-profits, but not exclusively. Again, could affect you if you're a nonprofit offering non-degree programs. So what's the triggering event? If the institution has gainful employment programs that could become ineligible based on their final DE rates for the next award year. Okay, so if that's the case, so if you fail in year one, or if you fail any year, at that point you have a program that could become ineligible in the next year. And as a consequence, you're going to trigger this financial responsibility requirement. So in other words, if you ever have a failing gainful employment, this is different. In the proposed rule, they were trying to say, well, if some percentage of your gainful employment programs overall, or, you know, if the percentage of your students in your failing gainful employment programs relative to your total student population exceeds X or Y, and they sort of ditched all that. And they just said, okay, here's the triggering event. If you have any gainful employment program that could become ineligible in the coming year. So again, if you ever have one that fails, because you would be ineligible if you failed 2 years in a row, then that means you would automatically have one of these triggering events. What's the reporting time frame? Well, there isn't one, because in this case, the department does the calculation and it's notifying you of your debt to earnings rate, so it's already going to know, right? It's already going to know. So how's loss determined? For the potential loss of eligibility for a gainful employment program, it's the amount of loss, right? The loss is the amount of Title IV HEA program funds that the school received in the prior year for that GE program, not total. But then again, here, as with the accrediting agency concept, here again, the department will recognize the reduction in educational expenses associated with discontinuing that program. Right, so there is sort of a counterbalance here when they're doing the calculation. And again, they are recalculated in composite scores. So if you've got failing GE programs, but they have very few students in them or very few students that are receiving Title IV, then it's entirely possible it's not going to have any sort of significant impact on your composite score, and you would not be deemed to lack financial responsibility. And I think net this is a win for schools that have a lot of gainful employment programs, because the formulation under the proposed rule wasn't nimble enough to take into account the material impact that those programs were actually having on your bottom line. And that was a lot of the commenters said, look, you've got this formulation where if somebody has, you know, the way they've worked it out, you could potentially be deemed to lack financial responsibility, even if you have very few gainful employment programs or very few students in those programs. So by developing this composite score mechanism and putting the gainful employment trigger inside the composite score category, what the department has done is it's created a way to really take into account the materiality of the programs that may be in danger of failing, right? And if they're small programs that don't have a lot of students, there's not a lot of Title IV, it's entirely possible that it would have no negative impact on your composite score, or at least wouldn't get you below 1, so that you wouldn't have any risk of being deemed to lack financial responsibility. Cohort default rates. What's the triggering event? The institution's 2 most recent official cohort default rates, right? And what you may recall, if you think much about CDRs, that to actually lose eligibility, you have to have, your rates have to exceed the 30% threshold 3 years in a row. So what the department's doing, right, sort of like it's done with gainful employment, is it's backing out a year. And it's saying, okay, if you're a year out from potentially losing eligibility, that's when you're going to trigger the financial responsibility standard, because the whole idea here is we're trying to create triggers that will give us a heads up if we think there's going to be a loss of eligibility a year later or at some point in the future, right? So if the institution's 2 most recent official cohort default rates are 30% or greater, that's the trigger, unless the institution files a challenge, request for adjustment, or appeal with respect to its rates for 1 or both fiscal years, and that challenge, request, or appeal remains pending. So in other words, within the typical CDR framework, if you've filed in a challenge or an appeal, you know, the event won't be deemed to have occurred until that runs its course. What is the reporting time frame? Again, there isn't one, because the department already knows. Just like with GE, it calculates the rates, so it's going to know. What can an institution do to mitigate the penalty? Well, file a successful CDR appeal, right? So let's talk about those discretionary triggering events, right? We have the two categories of what the department's calling automatic triggering events, and you've got the ones for which you have a recalculated composite score, and then the ones like failing 90-10, where if you fail 90-10 one year, you are, I didn't cover that, but the way the rule works, if you fail 90-10 one year, you are automatically deemed to lack financial responsibility, right? And really what they're doing there is they're saying if you fail 90-10 one year, again, you're a year out from potentially your whole institution losing eligibility. We consider that material and disconcerting, so we're going to automatically consider you to lack financial responsibility and require you to post surety, et cetera, right? But then you've got this other category that they call discretionary triggering events. So what is the triggering event? Well, there's a bunch of them, really. And the way the department sort of tees this up is they say, we will consider an institution to lack financial responsibility if we are able to demonstrate that there is an event or condition that is reasonably likely to have a material adverse effect on the financial condition, business, or results of the operations of the institution, including but not limited to. Now, before I get into the specific examples they give, I want to make 3 or 4 points here. The burden is on the department to demonstrate. Okay, that's good. On the other hand, the department is also the arbiter of whether or not they have sufficiently demonstrated, right? I mean, it's their determination. So you may not feel like they have sufficiently demonstrated that there's could be an MAE, but if they do, then they would be able to act under this regulation. So while I appreciate that they put the burden on themselves, on the other hand, given that they are the judge as to whether or not they have made a sufficient demonstration, I think that is, you know, it makes me a little more uncomfortable. Now, ultimately, if you disagreed with the department, and I suppose if you ended up in federal court, you could argue that they had not, in fact, sufficiently made that demonstration, and you would have someone else, in that case a judge, making the determination. But at least at the initial level, which is really the important one, because I got to tell you, if you're in federal court, you're a long way down the line and you're spending a lot of dollars and you hope not to be there, right? So what you'd really like to have seen is something with a little more protection. But here the department says, well, we'll take on the burden of demonstrating. I'm not sure how meaningful that is. Second, it doesn't have to actually be that there was a material adverse effect. It's just if the department believes it has sufficiently demonstrated that there is a reasonable likelihood of a material adverse effect. So again, this sounds like it's giving you a lot of protection, but you know, if in my mind I'm concerned that if the department wanted to, it wouldn't be too hard for them to say, well, we've determined that we have demonstrated that there is a reasonable likelihood that there could be a material adverse effect. I don't mean to be glib, but just when you're, you know, sometimes I will hear people talk about standards like this and they'll say, oh, well, look, there's all this protection. The department has to make the demonstration and it has to be an MAE. That's not what this language says, right? That's really not what this language says. At least it only has to be a reasonable likelihood of a material adverse effect, right? And then the last thing I wanted to highlight was this but not limited to. This is not an exhaustive list, right? So what the department is really saying here is if we think there is any triggering event, if anything occurs at your institution that we think is reasonably likely to have a material adverse effect, and we believe that we have sufficiently demonstrated that reasonable likelihood, then you are not financially responsible. In my mind, this is a pretty low threshold, and it gives the department a lot of room to if they wanted to, say we don't think an institution is financially responsible for any event, right, that they might find disconcerting. So what are the specific events that they actually listed? A significant fluctuation in direct loan or Pell Grant funding that cannot be accounted for by changes in those programs. We don't know exactly what a significant fluctuation is. The institution is cited by a state licensing or authorizing agency for failing state or agency requirements. I mean, this one I think is disconcerting because just about every school has some sort of state agency or authorizing entity that comes on campus periodically and will do little reviews with regard to how you're administering their particular program, and will have little findings and citations, right? I mean, again, the department would have to demonstrate there's a reasonable likelihood that this thing they cited would have a material adverse effect on the institution. And if you take that at face value, you would expect that these rinky-dinky findings would not satisfy that standard. But it still makes me a little uncomfortable. If the institution fails a financial stress test developed by the department, they talk a little about this in the preamble, but we still don't know exactly what this stress test would be. The institution is or was placed on probation or issued a show cause order, or placed on an accreditation status that poses an equivalent or greater risk. I highlight show cause because historically, simply being placed on show cause has not been the basis for a determination of a lack of financial responsibility, right? I mean, if you look through the data that's available that the department's made public, you will see that probation has been something they have acted on. I think in recent months, they have started to take the view that show cause is significant. I mean, clearly that's illustrated in the fact that they included it in this rule. And I think they've started to try to reflect that in the way they're going about their own enforcement proceedings. But historically, it was not. Show cause was not considered to rise to that level of being placed on probation or considered sort of at an equal level of risk. So I consider it significant because also historically, a lot of accrediting agencies have used show cause, I won't say flippantly, but with some regularity, right? With some regularity, and it is not uncommon historically, at least in my experience, that institutions that are placed on show cause have been able to get through that and demonstrate compliance with the accrediting standards and continue to be accredited. So this really raises the stakes for the use of the show cause, and it would be interesting to me if this rule sticks to see if it affects the way that accreditors use show cause, knowing now that if you place an institution on show cause, it will automatically trigger a departmental investigation into whether or not this has a material adverse effect on the institution, or is likely, I should say, to have one, which would in turn result in you being placed, potentially found to lack financial responsibility and placed in some sort of provisional certification or something like that. And you can see how these things spiral, you know, I mean, so you got an accreditor that puts you on show cause, that's reported to the department, then they turn around and they say, well, we think you lack financial responsibility, so now you've got to post a 35% letter of credit and we're going to put you on HCM1 or HCM2, and now the institution is strapped for cash, and the accreditor turns around and says, well, now in addition to the things we cited originally, you know, we have real concerns about your financial stability, et cetera. And so suddenly a pretty simple show cause order that may have had nothing to do with your financial responsibility has, in fact, in and of itself, damaged your financial stability, which, again, seems not to be the way that this should work. Number 5, the institution violated a provision or requirement in a loan agreement, enabling the creditor to require or impose an increase in collateral, a change in contractual obligations, an increase in interest rates or payments, or other sanctions, penalties, or fees. The institution has high annual dropout rates. We don't know what that is in terms of, you know, what is a high annual dropout rate, and what are the dropout rates the department's looking at? Is that the, you know, using iPads data to calculate that? Is that going to be a new calculation, that kind of thing? The institution has pending claims for borrower relief discharge. So what's really interesting here is this is wide open, right? I mean, is that 1? Is that 20? Again, you've got this, the department has to demonstrate that there's a reasonable likelihood of an MAE. So you've got in theory, a materiality standard there, but it's hard to know exactly, you know, what would be material, or what, because by the way, I should point out there is no definition of material adverse effect that's included in the law, to my knowledge. The department expects to receive a significant number of claims for borrower relief. So this one's interesting too. I mean, here, we're not even talking about there being claims that have been filed. The department is essentially saying, if we think that we're going to get a bunch of significant claims for borrower relief, and we think that's likely to have a material adverse effect, then we can take action. What's really interesting to me is, I'm curious how the department would demonstrate that they expect to receive a significant number of claims and that they expect that will have a material adverse effect on the institution. I mean, that's a whole lot of prognosticating, right? So it's interesting to sort of think about how that would work. But the other concern, of course, is if you listened in on Tuesday, that the department has itself the ability to initiate a borrower defense claim on behalf of a group of borrowers, even if it hasn't received a claim. So, you know, sort of putting 2 and 2 together, it seems to me that the department could say, well, we plan to initiate a group claim against institution X, and as a consequence, we now expect to have a significant number of borrower relief claims against that institution, and we expect, if we are successful in initiating this process against the institution, that it will have a material adverse effect. So, institution, by the way, we don't think you're financially responsible anymore. right? And now you have to post a big letter of credit. I mean, this just seems to be a way, if an agency were interested in targeting an institution or going after it to wreak a lot of havoc. And again, you know, the great hope here is that that would never happen, right? But my preference as sort of a risk manager is that we create systems that don't rely on people acting responsibly, right? I think the whole idea is you want to create systems that assume that sometimes people won't act responsibly, but that will still protect everyone. I mean, I think you could argue that that's the whole reason we have checks and balances, and the way our bureaucracy is designed is specifically for that, right? We assume that we will have incredibly ambitious and sometimes questionable people who are in all different levels of government, and so we've designed systems to hold that in check and ensure that we all still have procedural protections. And, you know, I look at something like this and it makes me very uncomfortable. What is the reporting time frame? So under the discretionary factors or events for state, and it differs, first of all, depending on which one of these events. And then, you know, it also raises the question, the department said this list isn't exhaustive. So there could be things that the department ultimately would determine was a triggering event but aren't on the list. How you would know that one of those occurred and you needed to report it to the department, I don't know. Seems unlikely that they could hold that against you. You know, the ones I do talk about, so for state or agency citations, 10 days after the institution is cited for violating the state or agency requirement. For probation or show cause actions, 10 days after the accrediting agency places the institution on that status. And the department's probably going to know anyway because your creditor typically will report that to the feds directly. For violations of provisions or requirements in a loan agreement, 10 days after the violation occurs, right? What can an institution do to mitigate penalty? Well, again, in all of these cases, right, even where you have a discretionary event, the department is taking the burden of demonstrating a reasonable likelihood of material adverse effect. You still have the opportunity to demonstrate that the triggering event no longer exists, has been resolved, or that you've got insurance coverage, right? Again, we don't know how much insurance coverage you would have to demonstrate for the department to say, okay, we don't think this implicates your financial responsibility. But it is really important that the way the law is structured, you should still have an opportunity to attack the notion of materiality. For violations of provisions or requirements in a loan agreement, you also have very specifically an opportunity to demonstrate that the creditor waived the requirement. However, there's also this little carve-out, because we love carve-outs in regulations. If the creditor imposes additional requirements as a condition of the waiver, the institution has to identify those additional requirements and demonstrate that complying with them will not adversely affect the institution's ability to meet its future financial obligations. All right, so processes and consequences. You've seen this slide before. We walked through it. I just wanted to remind you, you know, you sort of get the triggering event, and then you flow down, the department makes this determination, and it sort of varies whether it's a composite score triggering event or not, and then ultimately they may decide that you're no longer financially responsible, and if they do, you have to satisfy one of these alternatives. What are the options? You know, we talked about this at the outset. This part hasn't changed all that much. Again, I mean, you've got this letter of credit opportunity, which most people don't take because it's 50% or more. You could participate under the zone alternative. You know, I mentioned previously, in a little more detail we say here, this is only available in institutions that fail due solely to the composite score. So if the department determines that you are failing financial responsibility for one of those many reasons for which a composite score isn't recalculated, right, then the zone alternative in and of itself would not be an option. But the significance of being able to participate in the zone is it does not necessarily require that you post some form of surety. And then the third option is provisional certification. So in which case, typically you're doing a combination of providing some form of surety, a letter of credit historically at least 10%. You have to comply with the zone alternative. And then if you want to stay in the zone for more than 3 years, there is a way to do that, but it typically requires some sort of guarantee from third parties. So like for a for-profit, that could be an owner. For a private nonprofit, you know, that could be some other sort of board or entity. The department, importantly, a couple of things I wanted to note. First of all, I don't cover it here, but the department did expand the types of surety potentially and sort of specify the types of surety that could be provided by an institution. So historically, it's really been the letter of credit, but they also talk about, you know, taking cash or other types of things. One of the really important things they got rid of, you may recall in the proposed rule, the department had very explicitly said in the preamble, if you have a bunch of these triggering events, each one results in a 10% letter of credit at least, and those are stackable. So a lot of people said in their comments, including us, we said, well, wait a minute. I mean, there's a couple of problems here. One, what if you have a single event that occurs but potentially triggers 2 or 3 of these things? So, you know, you have one material event that occurs on campus, and as a consequence, you know, you have litigation and you have bar defense claims, and you also, you know, have some issue with 90-10, whatever. The point was you're being penalized and you're going to have these stacking letters of credit, even though really only one thing occurred on campus, right? And as a consequence of that one thing, several of these different triggers were flipped. And the department came back and said, okay, we get it. You know, you shouldn't be penalized for that. The other thing we pointed out is theoretically if an institution, I say we and other commenters too, but we said if an institution has multiple triggers, I mean, you could get to a point where they're having to provide you a letter of credit that exceeds 100% of the prior year Title IV receipts. And, you know, the whole way the regulations work and the idea of financial responsibility, you know, is that you are giving the department the security and surety that it needs so that if something goes south, you can cover all your obligations in their federal financial aid programs. If you're having to post a letter of credit an amount that's 200% of your prior year Title IV receipts, that exceeds the whole concept, right? That isn't consistent with the design of the surety, the purpose of the surety. And the department said, okay, fair enough. So they got rid of the stacking of financial penalties in the proposed rule. And they said, we agree with the commenters that an institution should not be required to provide financial protection for every automatic triggering event for which the underlying facts or circumstances are the same or where a direct causal relationship exists between 2 or more events. Within 30 days of notifying the department of certain of these triggering events, this is the other thing I want to make you aware of, you have a disclosure obligation. And this was in the proposed rule and it stuck around in the final rule. So an institution must disclose to enrolled and prospective students and post on their website that they, here's the interesting thing though. So they're saying within 30 days of the triggering event, but what we don't know is if within 30 days of the triggering event, a determination will have yet been made on whether or not you are financially responsible. So it's not entirely clear to me what exactly you're being required to disclose. I mean, they say the disclosure must clearly identify and explain the reason the institutions was required to provide financial protection. But again, my point is within 30 days of notifying the department of certain triggering events, there may not yet be a determination that you have to provide financial protection, right? So the way this law is written seems problematic to me on its face. I mean, certain of these events, if you provide information to the department, presumably it's going to take them a while to project the composite score or evaluate information you may provide and come to some determination on the materiality of the event and whether, in fact, you are required to provide financial protection. Also, it may take a while for them to decide how much for financial protection for you to provide. I mean, 30 days is a really tight window. So if this rule sticks around and you have schools that are subject to it, you may find yourself in a situation where you're having to reach out to the department and say, look, it doesn't make sense to us to make any disclosures yet until this stuff gets resolved. As I always like to mention at the end of our webinars, we have a blog, Regulation, where we talk about lots of different things. Very happy for you to check it out. We also usually post notifications if we're going to be doing webinars, things along those lines. That's me, and we are open for questions. So if a school has decided and has begun a location closure prior to July 2017, would this apply? You know, my view would be it's all about whether or not, well, you know what, it's going to depend. I think generally I would say it's when you actually pull it off the e-card. So let's say you've started a teach-out process and you start that this year, but, you know, you're offering bachelor's degree programs, so July 1, 2017 rolls by and you don't actually cease instruction until some point after July 1, 2017. The department considers an institution to be closed as of the point at which it actually ceases instruction. You know, what I'm thinking about is the real trigger, though, in the regulation is when you're required to provide that teach-out plan. So the question is going to be, at what point do you notify your accreditor of your intention to close the institution, and what point does the accreditor require you to provide the teach-out plan? That's really the trigger. If that occurs after July 1, I would anticipate that the department would expect that you would notify them of that event. What's interesting is, you know, if you're teaching out now and you've already provided a teach-out plan, let's say literally today, so July 1 is, you know, 8-9 months away, whether or not the department would say that you have an obligation come July 2nd at that point to put in some sort of notification, because, you know, theoretically the 10 days has occurred months before. So, yeah, it's a really interesting question. To the person who asked that, I mean, if you want to talk about it offline, I'd be happy to. I think for the moment, I would just wait to see if this rule sticks around, because certainly you don't have a reporting obligation any earlier than July 1. So you've got 7 months to see if this obligation still exists come July 2nd. I'd probably employ a wait-and-see approach. Regarding the recalculation of the composite score, would this recalculation be required if you add a location as well as a new administrative office? No, adding a new additional location in and of itself is not a trigger in anywhere in the law indicated as a trigger. Which triggering events would require disclosure to prospective and enrolled students? Well, so it's not a matter of which triggering events. It's, in my mind, although, you know, it's interesting. I mean, this goes to the point I was just making, right, on this prior slide. You know, the department says, and I would have to get in, oh, well, I have a TBD right there. So I think what that means is the department hasn't yet determined which triggering events would require disclosure, right? Oh, yeah, that's right, because actually what they've said in the preamble is that they're going to go through a process of, it's a great question. Thank you for asking. They're going to go through a process of doing some consumer testing, and they're going to try to figure out which of these types of triggering events are that students and consumers would find of interest, or at least they think they would need to know, and then they're going to let us know which triggering events would actually prompt a disclosure. But again, I think you've got the bigger issue too of, even despite the way the regulation is written, is it really that you have to disclose when a triggering event occurs, and certainly to the department, but I mean on your website and to your students, or is it once there's been a determination that you lack financial responsibility? I think it has to be the latter. That's not the way the law is written, but it doesn't make any sense to me that you would fashion a disclosure before a determination had been made as to whether or not you lack financial responsibility. And that doesn't make sense even given the way, again, that they've written the law, because what you're supposed to be disclosing is the reason you are required to provide financial protection. So if you're not required to provide financial protection, what would you be disclosing in the first place, right? Let's see. If a teach-out is required by an accreditor for a specific program and not a location, is that a trigger? I don't believe so. No, I believe that it's only a trigger if you're actually closing a location. Now, you know, if the location only offers one program, it would be one and the same potentially, right? With respect to a trigger for which the authorization to offer an educational program has been revoked, does the revocation say a state licensing or authorizing agency include professional boards such as nursing, or just the education regulating agency such as the state? Okay, so I think the point here is we have this trigger right here, right? So number 4, state licensing or authorizing agency notifies the accreditor that an institution's license or legal authorization to provide an education program has been or will be revoked. The key here is, has someone notified your, first of all, we're talking about your accreditor. I want to make clear that I believe that the department is talking about your institutional accreditor, not a programmatic accreditor that you may have. And so then the question is, you know, who exactly has to make that notification to the accreditor for this to be triggered? The department uses the language state licensing or authorizing agency. I think that probably is, you know, I don't know, and I should be clear that I don't know for certain. My instinct is that that is referring to the institutional agency, institutional authorizing entity, right? So the state entity that authorizes your entire institution to operate, and not, for example, for a state, the State Board of Nursing or something like that. But I do not know that for certain. I do not know that for certain. The other point I will make is there could be, it could have some impact, or it could depend in part on your specific institutional accreditor standards, right? Because if your institutional accreditor requires you for some reason, maybe they go above and beyond, you know, the department's regulations here, or they take a different interpretation, you know, if they would require a teach-out plan, in their view, if the state, you know, Board of Nursing were to inform them that they were revoking your license to offer the program, I don't know, the department might take a view that that triggers the obligation as well. But I don't know for certain. It's something that I would have to look into. Okay, addressing the materiality slide. An institution has insurance that will cover part or all of the debts and liabilities. Impact on institutions which are self-insured. You know, I don't know, but I would think that ultimately the calculation is still the same, right? I mean, whether you have outside insurance or you're self-insured, the point is if you have insurance sufficient to mitigate any impact that the underlying triggering event would have on the institution, and you can demonstrate that, I mean, the point is the department's going to take that in consideration. Again, I mean, the second question is, how much insurance do you have to have, right? Certainly if you're self-insured and you have some sort of catastrophic incident that you are now required to cover, I mean, that could have an impact on your institution, you know, financially in the future anyway, because of the fact that you're self-insured. I think the department would take all that into consideration. It's a great and very interesting question. All right, so that's all the questions we've got. Thanks to everyone for tuning in. As always, it is deeply appreciated. Let us know what you liked, what you didn't like, how we can improve things going forward. And please feel free to join us next Tuesday and Thursday as we sort of think about the other aspects of this rule.